Yes.
Made physiological.
Yes.
But I'd like to mention item number 5, my lord. My lord, in this, there is some talk going on in the government level. My learned friend, Miss M. Devi, is appearing online. If,
Okay.
some,
For M.
M. Devi for the government of Assam.
Okay.
It could be on some other day, my lord.
Okay.
My lord,
Some other day.
some other day, my lord. My lord, on 24th March, if it is not inconvenient, my lord.
Okay. Yes, sir. So he's not appearing today.
My lord, supposed to appear online.
Okay.
She's there. She's there, I'm told.
Okay. Mr. We deny Learned Council for the petitioner. Praise for listing this matter on 24th March. You have informed her.
Yes, my lord, she
Okay,
was
to
online here.
Okay, to which?
Maybe some connectivity issue.
Okay, Miss
Mrs. M. Devi.
M. Devi.
M for Mumbai.
Yes, M. Devi. Learned Council appearing on behalf of the
State of Assam.
state respondent, state of Assam. Has no objection. Prayer allowed. List this matter on 24th March. Okay.
There was an interim order.
The interim order passed earlier shall continue till the next date of listed. By the way, what is the stage of the trial in this case?
My lord, this has been because the charge sheet was filed after 12 years.
Oh, after 12 years?
After 12 years, the charge sheet was filed. And that too without any materials. No materials as against my client is concerned. And in fact, in a similar one, that was already quashed.
Charge not yet framed.
No. In a similar one, my lord, that has been quashed, my lord, by this honorable court of Justice Rishikesh Roy.
That was also involved with the
same a separate FIR, but same incident.
Same incident.
Same incident, a separate FIR.
Incident took place in Arunachal Pradesh.
The disputed area.
The petitioners are from Assam.
My lord, they are government officials. The present petitioner, my lord, he is a civil service officer.
Okay.
And
so your claim is that there is no prosecution sanction.
No prosecution sanction.
Okay, whether the prosecution sanction was required, necessary?
My lord, yes, my lord. Because he was in fact assisting in the maintenance of law and order. He was not involved in the operation at all. He was a EAC.
But the incident took place in Arunachal Pradesh only.
But that's a disputed one. That is why some government to government talks.
24 March.
Deeply.
My lord, I wish to mention item number 14 on behalf of L. Parme.
Yes, order. For what this matter has been listed for? Wait for some time. We'll see the record and pass order. Okay. We'll grant you adjournment, but wait for some time. We'll see the record. Okay.
Okay.
We have no idea what it has been listed. Okay.
May it please your lordship?
Yes.
I beg to mention item number 3 and 4. Your lordship, the Learned Council, Mr. G. Kato, is out of station and I'm appearing on his behalf and seek for a short adjournment. Your lordship, we had obtained the consent of the Learned Council.
Have you taken steps?
Yes, lordship.
Upon the respondent, no one is there. No one is represented or representing the respondent till date.
We have obtained the consent.
Okay, consent. Okay. Miss
Elori.
Learned Council submits that the conducting council, Mr. G. Kato, is out of the station, therefore pray for adjournment. She also submitted that she has obtained consent from the others. Other side is appearing, but then their name has not been reflected. Okay. Okay. Obtain consent from the Learned Council appearing on behalf of the other side. In view of the above and as prayed for. When do you want this matter to be listed?
After 2 weeks.
After 2 weeks. List this matter after 2 weeks. Okay.
Not sure, let's check.
My lord, I'd like to mention item number 7, 8, and 9.
7, 8, and 9.
Yes, ma'am. My lord, conducting counsel is from other state, my lord.
Criminal petition.
Yes, ma'am.
Not
My lord, can matter be fixed on 5th of March, ma'am?
5th of March.
Yes, ma'am.
Okay. Who is for the other side? Tanya Kisna.
Yeah, I am from the other parties.
Have you informed?
Yes,
Okay. Mr.
the other man.
Diado, land counsel for the petitioner with the consent of the land counsel appearing on behalf of the respondent. Prays for listing this matter on 5th March. The prayer is allowed. List this matter on 5th March accordingly. Okay.
My lord, there is a intended negligence.
The interim order passed earlier shall continue till the next date of listing.
Much of
May I please, Your Lordship? Lordship, I'm here appearing on behalf of I am Your Lordship. Item number 26 and 27 may be adjourned, Lordship, for the day.
You are for appellant.
Appellant, Your Lordship.
Okay. Have you informed the land counsel for the other side?
Yes, Your Lordship.
Okay. You are Mr.
T. Pavan. Lordship, I would like to submit this item number, this matter may be fixed on 5th March, Lordship.
Okay. Mr.
T. Pavan, Your Lordship.
Land counsel appearing on behalf of Mr. I. Ahmed,
I am
land counsel for the appellant with the consent of the land counsel appearing on behalf of the respondent. Prays for listing this matter on when?
5th March, Your Lordship.
So why and everything or entire matter will be fixed on 5th March? Why not 6 or 7?
Lordship, the other party have, I think other parties engaged on another cases, Lordship. So
We'll fix out it on either 9 or 3 March. Because earlier 2 matter already fixed for 5th March.
we have already.
Lordship, it may be fixed on 10 or 11, Lordship.
Okay, 10 March.
Deeply obliged, Lordship.
Your Lordship, there is in item number 4, there is adjournment.
Item 4, the interim order passed earlier shall continue till the next date of listing. Okay.
My Lordship. Lordship, I'd like to mention item number 25.
25.
Lordship, here some accommodation may be granted, Lordship.
Hmm?
Some accommodation may be granted as Mr. T. Pertin, counsel for the respondent is not present here today, Lordship.
You are for Mr. T. Patin.
No, Lordship. I'm appearing on behalf of M. Kato, Lordship.
Okay. Ms. Gao, land counsel appearing on behalf of Mr. M. Kato, land counsel for the petitioner. You have obtained consent.
Lordship, he is not present today, Lordship. Therefore, accommodation may be granted, Lordship.
He is not?
Not present today, Lordship.
Who?
T. Pertin, Lordship.
Okay. You are praying on behalf of Mr. M. Kato or T. Patin?
Lordship, M. Kato, but T. Pertin is not present today. Therefore,
The
some.
matter has not yet been called.
Yes, Lordship, but T. Pertin is not present in court premises, Lordship.
Now he may not be present, but by the time it is called, he may be present. This is hearing matter. You inform him then?
Yes, Lordship.
When?
Lordship, after 2 weeks.
Okay. Pray for listing this matter after 2 weeks. The prayer is allowed. List this matter after 2 weeks. Okay.
Obliged, Lordship.
May I please, Lordship?
Hmm.
Lordship, I beg to mention item number 28. Here, Lordship,
There is
engaging,
28 also.
yes, Lordship.
Okay.
The engaging counsel For respondent number 4, 5, 6, 22, and 23, Mr. Atnu Ganguly is not well, so he won't be able to appear. Kindly, next date maybe, fixed date may be given.
Which date? This was fixed.
Madam, actually on my period, madam, has been fixed today, madam, with the
Yes.
consent of the other party.
Mm.
Madam, however, madam,
You are also for respond.
yes, madam, I'm
Okay.
the respondent number 1, madam. Now,
Okay.
madam, the other, madam, my learned friends, appearing for the
Ganguly.
respective, madam, the case persons are expressing their difficulties, madam.
Mm.
Madam,
Okay.
so-
So whether the
The difficulty with Mr. Ganguly is he is really ill and fallen sick.
okay.
So we cannot force a person who is on the sick bed to come here
Right.
and argue the matter.
Okay.
And secondly, my lord, this is a matter where firstly, the prosecution has to advance their argument.
Yes. Mm.
Now, one, the High Court, standing counsel of the High Court, one
On the
by
side
the
of court.
amicus, another by the state, and followed by the argument advanced by all the counsels who are representing the private respondents. Because, my lord, even though the suo motu case has been registered, but it will not be applicable against many of the respondents, my lord. Because due service was given to them, notice, they were put on notice, they represented, and accordingly, role of every respondent has to be placed on record. And secondly, my lord, thirdly, the corollary argument to substantiate whether this injury is maintainable or not. That is also one ground where we will be arguing on the criminal jurisprudence, my lord. It will not be a one-day task, my lord. Minimum, it will take 3-4 days in this matter to dispose of because more than 30 advocates are representing. So therefore, my lord, give us some
Altogether
time.
involving how many cases?
Only one case, madam, out of only.
Only in one case, but then the separate bail application was filed.
Yes, yes, sir.
Yes.
Separate.
I-
Oh, how many accused altogether?
Uh,
Around 12,
How many? 32 something.
32.
32 accused.
Okay, then it will take time.
Yeah, because the
I
rules
want-
are very different, my lord.
Okay,
So, my lord,
Anyway.
some substantial time because Mr. Ganguly is really ill
okay.
and then he may not recuperate in 2 weeks' time. And my lord will see that if this case is listed again,
Hmm.
it should be from Monday only. From Monday to till Friday, we will have all the times, my lord.
Okay, so,
For the last.
Mr. Counsel for the High Court
If I may
is
please.
also not present. He is,
No, they are
he's-
there, my lord.
He's on like in the court number 2. So we are not communicated well. We are not aware of the adjournment today. So your lordship, he may be allowed to like present in the before this court.
No, but there is a health ground. So somebody is seriously ill and then you cannot force somebody to come.
so he is on leave.
Madam,
Yes, he is on
the
that.
urgency was expressed by me, madam, my colleagues, all the, madam, the colleague, madam, representing the.
Okay, so what we'll do, let him be present, but then of course adjournment will be granted. I've heard you. So, yeah, for respondent number 1 is present,
Number 1, madam.
I am
One
for the
is present.
7.
7. 2. 2,
22.
22, 15.
Give
Okay,
your names in the slip because.
so give the slip,
Ah.
whosoever present, okay, name of the respondent number and the name of the council.
Correct.
Okay, so since the prayer is on the health ground, so just inform.
Yeah.
And I don't know when he's ready,
Yeah.
free, just will
Madam,
pass adjournment order.
Yeah.
Since they are making
Yeah.
adjournment.
Madam,
So
that's,
in absence of the council, it will it will
kindly
difficult to.
keep in mind also,
Hmm.
in this particular fortnight, it
Ma-
cannot be done because the bar election is
Okay,
on now.
so, and
And
everybody
everybody is-
it has to be on Monday,
And it
Monday
should
after
be
2 weeks.
After 3 weeks, my lord.
after 3 weeks,
After,
on Monday,
any day
Any-
on Monday.
okay, any day, okay, after 3 weeks.
Correct.
Okay. So someone be present, okay, not necessarily all,
Fine, my lord.
okay,
fine.
give the name and okay.
Grateful.
Obliged.
Item number 1,
May it please your lordship.
Yes.
Lordship, in this matter, there was an IA wherein the condemnation, a prayer was made for condemnation of the matter, your lordship, and that was allowed, your lordship. Subsequently, this
Condemnation was allowed.
and subsequently this matter has come up for the first time today, your lordship. Your lordship, the factual metrics of this case is that the father, who is the respondent, petitioner number 1 in this matter, had given a land of 1,000 square meter, 60% to petitioner number 2 and 40% to the respondent number 1, your lordship. Subsequently, the father himself has filed a complaint before the deputy commissioner that the elder son, who is the respondent number 2, has encroached certain part of the land of petitioner number 1, your lordship. And if I may take your lordship to the complaint, which your lordship will find at page number 27, your lordship.
So that means the petitioner and the respondents are
All related, your lordship.
blood brothers.
Petitioner number 1 is the father of petitioner number 2 as well as for the respondent number 1, your lordship. More particularly, he is the donor of the land in dispute. This matter.
Okay, so he has given the land
Yes,
to the petitioner number 1,
as well as to the respondent number, respondent
60% to petitioner number 1,
1 and 40%
and 42.
respondent number 2, your lordship.
Okay,
If I may,
then what happened?
subsequently, the 60% of the land that was gifted to the petitioner number 2, the petitioner number 2 had applied for an LPC, your lordship.
2. Petitioner number
Number
2.
2
Okay,
applied for a LPC, your lordship will find that in
LPC for his share of land,
his share of land, your lordship.
60%.
60% of land.
It was granted.
It was granted. Your lordship will find that at annexure A, page number 25.
So this 60 LPC is in respect of the 60% of the land donated by your father.
Gifted by the
Page?
father. Page number 25, annexure A.
This is LPC.
The petitioner number 2 is Dami Kamduk. This is for the land measuring up to 5,358 square meters, your lordship.
Okay, this is this consists 60%
Yes.
of
Your
the
lordship will
gifted land.
see, your lordship will just record the date of issue of the LPC, which is on 27th of June, 2019. Now, if I may take your lordship to the complaint filed before the deputy commissioner, which is at page number 27, your lordship. Page number 27. Complaint filed by the donor, your lordship. Against respondent, your lordship, who is
Why?
the elder son of the,
Why?
because he had encroached upon the land of the petitioner number 2, your lordship.
So the father lodged complaint.
Complaint against his elder son, your lordship. Your lordship will record that petitioner number 1 is the father, petitioner number 2 is the youngest son, and the respondent is the elder son of petitioner number 1. If your lordship come to page number 27, the entire case would be much more clear, your lordship.
Oh, page
27, which is the complaint.
27. Okay. Yes.
If I may read, your lordship.
Yes.
Through this application, it is to bring into your notice the following points for kind consideration and appropriate action. There I have 3 sons, namely Damli Kamduk, eldest. Your lordship will record that this is the respondent. Shri
one?
Damli Kamduk,
Okay.
Shri Damrik Kamduk and Sri Dami Kamduk. Dami Kamduk is the youngest, who is the petitioner number 2, Your Lordship. And I am a permanent resident of Pakam village. That all my immovable properties located in Pakam area were given to my 2 elder son, namely Damli Kamduk and Sri Damri Kamduk. My youngest son, namely Sri Dami Kamduk, did not even get a small plot to construct dwelling house, his birthplace, that is Pakam village. Considering this, I have given him Sri Dami Kamduk, the WRC field cum residential plot measuring around 10,000 square meters located at Sipupui near Neftu. That few years back, out of love and affection towards his elder brother, namely Sri Damli Kamduk, and after discussing with me, Dami Kamduk allowed him to cultivate 40% of the WRC field behind his plot. And in the year 2019, my youngest son, Sri Dami Kamduk, wanted to obtain LPC for the said plot. Then I went to the WRC field located at Sipupui near Neftu, and I personally demarcated 60% of the land measuring 5358 square meters. Thereafter, my youngest son, Sri Dami Kamduk, had duly obtained land possession certificate by so-and-so dated 27/6/2019 for a plot measuring 5358 square meters, leaving 40% of the land that is being cultivated by my brother. That I purposefully left the remaining 40% of the land because I thought that I will give some portion of the land from Pakam village, which was in possession of my eldest son, Sri Dami Kamduk, as a compensation to my youngest son for the 40% land that is left out at WRC field located at Sipupui, Neftu. But in future, if my eldest son, Sri Dami Kamduk, fails to give some portion from his land at Pakam area, the said 40% of land at Pui near Neftu shall be given to my youngest son, Sri Dami Kamduk. That, to my shock and surprise, without my knowledge and giving some portion of the land from Pakam area to my youngest son, Sri Dami Kamduk, my eldest son, Sri Damli Kamduk, started claiming around 900 square meters approximately inside the plot for which Sri Dami Kamduk has a land possession certificate and constructed a kacha fencing. Due to this, there was extreme tension breathing that time, but I intervened and asked them to keep calm and promised to call for a family meeting or local kaba for amicable solution. That now the agriculture season is arriving, and if the matter is not amicably solved, there will be a breach of peace and violence may also erupt between my 2 sons, Sri Damli and Sri Dami Kamduk. That the ownership and title of 40% portion of land that is under my elder son's occupation shall be decided by appropriate forum such as family meeting or local kaba in coming days, but for the occupation and possession of the plot measuring 5358 square meters of land for which my youngest son, Sri Dami Kamduk, has LPC number so-and-so, dated so-and-so, may be secured in favor of him before any eventuality happen. So this was the complaint filed by the father, that is the petitioner number 1, before the Deputy Commissioner.
Okay.
Subsequently,
Now, now what happened?
Subsequently, there was also an affidavit which Your Lordship will find at page number 2.
No, this is fact about the case. What happened thereafter?
Thereafter, what has happened was, if Your Lordship then come to the page number 32, Your Lordship. Your Lordship will see when the complaint was filed. The complaint was filed in the year February 2021, when the civil court the Arunachal Pradesh civil court did not come into existence, Your Lordship. Subsequently, after the coming of the civil court, the Deputy Commissioner made a suggestion that the matter be taken up by placed before the customary court or the regular court, Your Lordship. Subsequently, the complaint was filed on before the
Customary court
customary court, Your Lordship.
Customary court decided.
Customary court decided. Your Lordship will find the
In whose favor?
in the favor of the elder brother, which is the respondent in this matter, Your Lordship.
Elder brother is not having LPC.
Not having LPC. I'll just come. Why was this made, Your Lordship? Now, if Your Lordship will come to the impugned Kaba order, which is at page, it starts with page number 33. And the translated copy is at page number 37, Your Lordship.
Yes.
If I may read, Your Lordship. That today on this 29/4/2022, as per order number so-and-so dated the 24th March 2022, the village authority along with wise men gathered together at Sipupui WRC field, and upon hearing Sri Dodam Kamduk, Sri Damle Kamduk and Sri Dami Kamduk, the village authority decided the case as under. LPC dated so-and-so obtained by Sri Dami Kamduk was divided into 50/50 on dated 22, it should be 20.
LPC was obtained by younger
brother, Your Lordship.
Younger brother.
Yes. By Sri Dodam Kamduk, Sri so-and-so.
Otherwise, LPC was granted. Oh, sorry. The land was gifted to him, 40% of land was gifted to him.
The respondent, Your Lordship. 60% LPC was made by the petitioner number 2, Your Lordship. 40% was given to the respondent, Your Lordship. Subsequently, respondent,
No, the respondent is elder.
elder brother, Your Lordship. The respondent subsequently made a kacha boundary encroaching the land of the
Okay.
younger brother.
Complaint lodged.
Yes. LPC dated so obtained by Sri Dami Kamduk was divided into 50-50 on dated 22-2020 by Sri Dodam Kamduk, Sri Damle Kamduk, Sri Dami Kamduk, maternal Anka Sri Nyamin Atta and Sri Jumli Atta, Larji Kamduk and Lee Bagra. In the copy of the partition deed of WRC files in between elder brother and younger brother had been signed by complainant Sri Dodam Kamduk and Sri Dami Kamduk, and hence the LPC so and so is hereby nullified by the Kaba, and hence Sri Dami Kamduk is directed to withdraw the LPC. First, Your Lordship will see that does the village authority have the power to direct for withdrawal of the LPC or nullifying the LPC, Your Lordship. The second point of the Kaba is that Kaba further directs Sri Dodam Kamduk to provide an area for construction of residence in favor of his son, Sri Dami Kamduk. Sri Dodam Kamduk voluntarily agreed to give his Toko 3 garden situated at Pakam village in favor of his son, Sri Dami Kamduk, and further said that none of his family member, including his children, shall claim the same in future after his death. That from today onwards, none of the child can sell out the property inherited from their father, and in future, if any of the children sold the property acquired from their father, then father shall take back such land free of cost. Now, Your Lordship will see that the complaint was basically before the Kaba for encroachment, Your Lordship. The Kaba comes to a conclusion that there was a meeting on 22/2020 and the LPC was divided into 50-50, and therefore the LPC, nullifying the LPC, Your Lordship, and further directing that the
LPC was obtained by the petitioner.
who was given 60% of the land. Your
Okay, 60%.
Yes.
So 60% is 5,000.
5358, Your Lordship.
Okay, now the Keba says that this LPC 60%.
No, I'll just, if Your Lordship just allow me, I'll just continue with my submission, Your Lordship. Your Lordship sees that the Kaba come to a conclusion that there was a meeting conducted on 22/2020 by all these parties along with their maternal uncles and relatives, whereby they have decided the LPC to be divided into 50-50, and that the LPC, nullifying the LPC, Your Lordship. The second part is that the petitioner number 1, who is the father, was directed to give or provide a land to the petitioner number 2 for construction of a land in other place, Your Lordship. Thirdly, third point that was discussed was that none of the children shall sell or sell their property to any person without the consent of the father, Your Lordship. Now, agree with this order, Your Lordship, we had approached the appellant court, Your Lordship.
Okay.
Your Lordship will come to the now.
Appellant uphold.
Yes. Prior to that, Your Lordship will see on the point 1, there is a discussion with regard to 50-50 division of LPC of 50-52 on 22/2020. Now, if Your Lordship come to page number 39, Your Lordship, this is the agreement which the Kaba has reflected in their order, Your Lordship. 39 is basically the agreement. Your Lordship will see the type copy at page number 42, Your Lordship. Now, Your Lordship will see that this is not a Kaba nor any kind of legal entity which can decide upon the issue, Your Lordship. If I may read, Your Lordship. Demarcation of land in between Sri Damli Kamduk and Sri Dami Kamduk, son of Sri so-and-so of Pakam village, to whom it may concern. Today on this day, 20 February 2020, we several persons whose names are inscribed below redemarcate gifted land of Sri Damli Kamduk and Sri Dami Kamduk by Sri Dodam Kamduk, father, in presence of Sri Jumli Atta, son of late Kojo Mata, the actual landowner, with following conveyance. That today on this ward, earlier land demarcated in between Sri Damli Kamduk and Sri Dami Kamduk will come to halt, and the will remain null and void will be effective from today, that is 20/2/2020, redemarcation by assembled members. That the land possession certificate issued by the Deputy Commissioner allow in favor of any or either of the party before this convenience will remain halt, meaningless and null and void. That both the parties, Sri Damli Kamduk and Sri Dami Kamduk, will share, remeasure the redemarcated land to ascertain the actual area of demarcated land and shall apply for fresh LPC from competent authority. Sri Damli Kamduk and Sri Dami Kamduk will provide a space of 5 meters and 1 meter distance of land on the depression side of the land adjacent to Sipupui area stating from Darka main road upon the land upon the end of the boundary of Sri Damlo Kamduk for construction of road and drain respectively without prejudice. We several persons whose names are inscribed hereby solemnly affirms in presence of Sri Damlu and Dami Kamduk were present during demarcation. Further, both the party has agreed and satisfied this conveyance with sound knowledge and mind and has promised not to object and oblige this conveyance agreement. Now, your lordship will see that this several person does not constitute a Kaba. They were just a relative of the parties, your lordship. They-
Whether this settlement was signed by the father who gifted.
Yes, all of them signed it.
Okay,
All of them signed it. But if I may take your lordship back to the same, because this agreement does not apply only to me. It applies to all the parties. If I may once again read the relevant line, your lordship. At page number 42, your lordship will see. Redemarcated land of Sri Damli Kamduk and Sri Dami Kamduk by Sri Dodam Kamduk. Your lordship will see the land redemarcation is to be done of both the lands, not only the land of the petitioner number 2, your lordship. Secondly, your lordship, the LPC cannot be made null, cannot be declared as null or invalid or meaningless or void until unless a proper procedure is being followed as per the Arunachal Pradesh Land Settlement Act, your lordship. Thirdly, your lordship will see the third line that both the parties, Sri Damli Kamduk and Sri Damli Kamduk, shall remeasure the redemarcated land to ascertain the actual area of demarcated land and shall apply for fresh LPC from the competent authority. There is a admitted fact that till this date, neither of the party, it's not only me, but neither of the party has redemarcated, nor remeasured, nor applied for any new LPC, your lordship. Now, subsequently, agree with the Kaba order, or lastly, your lordship will see at page number 43, which is the list of witnesses, your lordship. Page number 43.
yes, yes.
43, your lordship will see at serial number 1.
Name of the petitioner number 1.
One is the Damli Kamduk, respondent number 1. Dami Kamduk is petitioner number 2.
Yeah.
And down below, your
No,
lordship will
just-
see.
Petitioner name is
Petitioner name is Dodam Kamduk, your lordship, and Dami Kamduk.
Dodam.
Dodam Kamduk, who is the donor, your lordship.
Where?
Who is the
Okay,
donor?
Dodam is there.
Yes. And Damli Kamduk is the respondent number 1.
Damli.
Is the sole respondent, your lordship.
Where? Which one?
Damli Kamduk.
Damli.
Your lordship will see.
There are 2 Damli.
The second is wrongly typed as Damli. The one in the right hand side is Dami Kamduk, your lordship.
Yes, Dami.
Yes.
Okay.
Now, your lordship will
Yes,
see
sir.
in the list of witnesses, your lordship. Your lordship will find Jumli at the page number 43, your lordship. The declaration, your lordship.
Yes.
Page number 43, your lordship
Mm.
will find. The witnesses is Jumli at the first witness, witness number 1.
Yes.
And second is Nyaminata.
Yes.
Now, if your lordship will then come back to page number 34, your lordship.
Yes.
Your Lordship will see the Kaba members, list of Kaba members, Your Lordship. Down below at serial number 11 and 12, Your Lordship will see Jumli Ate and Yamin Ate, Your Lordship. At page number 34, Your Lordship.
Hmm.
Down below, Your Lordship will see Kaba members.
Okay.
Then is Jumli Ate and Yamin Ate.
Hmm.
Now, Your Lordship is well aware that any person who is interested in certain case cannot be a judge in that particular case, Your Lordship. Subsequently, agree with the order of the Kaba, Your Lordship. We had approached the court of appellant court, Your Lordship,
Okay.
at Alo.
Okay.
The Lordship will, after hearing the party, the matter was finally disposed of in favor of the respondent. Your Lordship will find at page number 105.
Okay.
This is the impugn order, Your Lordship.
Okay.
I won't trouble Your Lordship with the entire judgment and order.
What is the decision?
I would like to rely upon three issues that was read, which is at page number 113, Your Lordship. 113.
What is the conclusion?
Conclusion was in favor of the in favor of the respondent number, in favor of the sole respondent, Your Lordship. Only basing on that particular certificate of 2020, Your Lordship.
Certificate of?
2020, Your Lordship, where the redemarcation and invalidation of the LPC was declared by several people as per the certificate, Your Lordship. If I may take Your Lordship to page number 113, Your Lordship.
Why?
This is the issue that was framed, Your Lordship.
Hmm.
Your Lordship, down below will see paragraph 9.
Hmm.
Having gone through the memorandum of appeal of appellant and reply filed by the respondent against the appeal, and also considering the submission advanced by both parties, the issue before this court for determination in present appeal is whether the appellants are stopped from claiming and disputed land on the basis of redemarcation decision reached in between disputed parties on 20/2/2020. Two, whether the village authority customary court has committed illegally by deciding and holding in the impugned Kaba decision that LPC number so and so of dated so and so issued to appellant number 2 as nullity. 3 is whether there is a procedure lapse committed by the customary court village authority which warrant intervention of this court, Your Lordship. Now, after framing of this issue, Your Lordship will come to page number 116.
Okay. What is the decision?
Decision was in favor of the respondent, stating that we have considered to the agreement reached on 20/2/2020, and therefore we are
Okay. But what is the defect in the decision?
There is a defect.
What is the jurisdictional defect?
Wh- because-
Jurisdictional error. This is civil revision.
Yes,
Okay.
yes.
What is the jurisdictional error?
First, Your Lordship will see that, as I have already reflected, that any judge deciding a case, Your Lordship, cannot be an interested person in that particular case, Your Lordship. Your Lordship will see that those two persons who were the Kaba members in that particular, while deciding that particular impugned order, Your Lordship, were a party to that certification, where on the basis of which the Kaba has made a decision, Your Lordship. They were not as a witnesses, but as a Kaba member, Your Lordship. That, secondly, that, Your Lordship, that
So that what was that demarcation one? That was on mutual settlement only, it appears.
yes, it was on mutual settlement. This was not particularly a mutual settlement.
Okay. Then,
At a family gathering.
Then- but then subsequently, who filed this complaint before the Kaba?
The father, Your Lordship.
Father.
Yes, the donor.
Okay, but then are
Lord,
they
I'll just-
are they GB or HGB, those persons?
There is nothing as such to if they were GB or not in the their resignation, Your Lordship. in the reflected in the Kaba order.
Where have you stated that they participated? What is the ground for challenge?
My ground for challenge is, first of all, if your lordship, I'll just come short reading of the impugn order pass in appeal, your lordship. If your lordship will come to page number 121, your lordship. Paragraph 14, your lordship. Having reiterated the law regarding principle of waiver, estoppels, and re judicata, let me examine as to whether the
No,
principle.
come to the ground. What is your ground?
My ground, your lordship.
The learned appellate court has decided against you.
Yes.
Okay, what is the ground?
My ground, your lordship will find at page number 13 of my petition, your lordship.
Yes.
Your lordship will find it ground number B, your lordship. For that, so-and-so failed to appreciate the fact that the Kaba members did not constitute Gam, Buras, and Buris, and were decided on the influence of other members who were also arbitrarily included as Kaba members. Second, your lordship will see ground C, for that the learned civil judge has failed to appreciate that village authority has no power or jurisdiction whatsoever to nullify the LPC issued to the petitioner number 1, nor can the village authority direct the petitioner number 2 to surrender his LPC. The issuance or nullification of the LPC can be solely done by the deputy commissioner of the respective district under the Arunachal Pradesh Land Settlement and Records Act 2000. However, in the instant case, the Kaba member, while passing the impugn order, that so-and-so has gone beyond their jurisdiction to nullify the LPC of the petitioner number 2. Third, your lordship, D, for that the civil judge failed to appreciate that demarcation made on 20/2/2020 was neither executed nor was brought before the notice of any appropriate authority in order to change the land possession certificate of respondent number, petitioner number 2.
What is the direction? Direction is to, whether the LPC has been set aside?
No, your lordship.
Then
There was a direction by the
the direction is only just probably, where was that? Kaba
lordship.
decision?
Find at page number 37, your lordship.
It's only said hereby nullified.
Yes,
Okay,
your lordship.
then Sri Damli Kamduk is directed to withdraw the LPC. It's only
No, your lordship. And see, hence the LPC here is hereby nullified by the Kaba.
nullified. That is
Now, can the Kaba
that is not-
nullify?
see, that will not affect. But then the last it says because they cannot nullify.
Yeah, absolutely, lordship.
But
Now,
it says that directed to withdraw the LPC.
yes, we have not withdrawn, your lordship. Now, first is that can a Kaba, without having any jurisdiction in issue with regard to nullification of LPC, pass an order that nullifying, they have not even considered the fact that the parties has executed that particular certificate or
The Kaba says that they do not agree with the LPC obtained by the respondent. And then after decision on mutual, probably, it was on mutual only, since the party has mutually agreed. And then after this decision, since they have divided 50 into 50 is to 50.
No, your lordship. That's why I was coming.
Divided into 50 into 50.
No, that
50
was
is to 50.
no.
What is this then? LPC.
That's
Come to page 37.
yes. that-
LPC that is obtained by Dami, Kamduk was divided into 50 is to 50.
Yes. That is what the
And-
Kaba has come up.
After this division, the Keba directed that Dami Kamduk is directed to withdraw the LPC only.
They
They cannot
cannot
set aside,
Yes.
nullify or request
Yes, but
the
then
LPC, but then only directed the person to withdraw the LPC.
absolutely, Your Lordship. My contention here is that, Your Lordship, the Kaba cannot, Your Lordship has rightly pointed out that Kaba has no power to nullify the LPC, Your Lordship. So
No,
we
that is
will,
why they said that directed to withdraw the LPC.
no, Your Lordship will see that a line above that, Your Lordship, the LPC number so and so is hereby
So
nullified by
they,
the
they
Kaba.
nullify,
They
because,
nullify. They don't have the jurisdiction.
no,
to
no,
nullify it.
they cannot.
Yes,
That is what they nullify.
yes,
According to them,
yes,
this LPC he has obtained probably illegally.
yes,
So that is why they said that we don't agree with the LPC.
yes,
That's why it's nullified. Therefore, the person, Dami Kamduk, is directed to withdraw the LPC.
yes,
They don't say that the LPC passed by or issued by the DC is nullified.
yes. Your Lord,
That will not be effective one.
yes,
It doesn't say so also.
I absolutely understand, Your
Hmm.
Lordship. This is not, the LPC cannot be nullified by any authority except
Yes,
for the DC
Except, yes,
under the Land Settlement Act. No, therefore, I was, the Kaba, being a civil court, has invoked beyond their jurisdiction while nullifying the LPC, Your Lordship.
otherwise you see, the decision and then it was upheld. I don't see any jurisdictional error here.
There is a jurisdictional error, Your Lordship will find that firstly, the Kaba has nullified the LPC, which they cannot do, Your Lordship.
No, the Kaba only directed to withdraw.
No, Your Lordship will see the nullification.
They nullify. It's not effective to the deputy commissioner, not directing to the deputy commissioner,
No,
not nullifying. They say that we nullify.
we
We
nullify.
don't,
The Kaba
we
nullifies
don't
it.
agree with this.
Yes.
That is why you should withdraw this,
And therefore,
because you have obtained this illegally.
therefore, the impugn order itself is wrong, Your Lordship. Can they decide anything on LPC? Can the Kaba decide
No.
anything on LPC?
Yes, why not? They can only at least decide that you withdraw this, LPC because it was illegally obtained.
Yes, Your Lordship, a line
They
prior,
don't say.
a line prior to that.
LPC is nullified.
No, it says, Your Lordship, is hereby nullified
No.
by the Kaba.
So this nullify, it doesn't say that it nullifies the LPC itself.
No, Your Lordship.
Therefore, nullifying the obtaining of LPC by the respondent, or sorry, the petitioner, they only say that directed to withdraw.
Your Lordship,
He is directed only to withdraw the
no,
LPC,
no, Your Lordship.
which you have obtained illegally.
No, I'll just read the line, Your Lordship. In the copy of the partition deed of WRC field file Sipupui in between elder brother and younger brother had been signed by the complainant Sri Dodam Kamduk and Sri Dami Kamduk, and hence, Your Lordship will see that the conclusion, and hence, the LPC number so and so is hereby nullified by the Kaba. So they have nullified it. When they
Anyway,
come to a decision that hence the LPC number so and so dated 2007 string is,
See, if this is effective one, then why the Kaba would say that Kamduk is directed to withdraw the LPC?
absolutely, Your Lordship.
So that is why the effective order is directed to withdraw the LPC, not the nullify.
No. Anyway, Your Lordship.
Anyway, so we
Subsequently,
will issue order, issue notice then.
Your Lordship, I have a small prayer for interim, Your Lordship.
What interim?
Why, my small prayer is for stay of this Kaba order, Your Lordship. Your Lordship will see that my initial prayer was for there was an encroachment, Your Lordship. The Kaba has entirely relied upon the document which has not been executed before any appropriate authority.
Land Council for the petitioner. This civil division petition under section 115 of the Code of Civil Procedure has been filed by the petitioner assailing the Keba order. When the Keba was passed,
Kaba was passed on 29/4/2022, Your Lordship.
Okay. Showing the impugn order dated 24/5/2024 passed by the Civil Judge Senior Division, West Siam District, upholding the Keba decision dated 29/4/2022. So it is submitted that
Your Lordship,
the Keba,
Your Lordship,
yes,
I have a small citation because the entire matter was with regard to estoppel, Your Lordship.
just a moment. Keba, this Keba was decided on 22. The village authority, the customary court doesn't have power and jurisdiction to nullify the land possession certificate issued by the deputy commissioner in favor of the petitioner number 2. However, by the impugn Keba decision dated 29/4/2022, it has nullified the Keba decision and by doing that the Keba has exceeded the jurisdiction exceeded beyond their jurisdiction. And by an order dated 24/5/2024, the Keba decision has been upheld by the Lalit Civil Judge Senior Division. Hello?
Hello, Your Lordship.
Okay, stop. Issue notice. The petitioner shall take steps upon the respondent by a speed post as well as by usual process within a week from today. Start.
Your Lordship, my friend here is already representing the respondent, Your Lordship.
You are
I'm appearing for the respondent, madam.
Yeah.
okay.
Because in the IA, for condemnation of delay,
You appear.
notice was
Okay.
sent.
Then you have for respondent number
Sole
Sole
or
respondent.
sole respondent.
Yes.
Then what is your submission?
No, I haven't received the copy of
You serve copy?
Yes,
Okay,
yes.
since Mr.
the other one.
Yeah, the Land Council would appear an accepted notice on behalf of the sole respondent. No formal notice need be issued. Stop. Par. List this matter. And then we'll say call for the record, the trial court records, including the Keba proceedings. Okay, after reading issue notice, and then please. Okay, list this matter after
3 weeks, madam.
3 weeks.
In the meantime, we will file our affidavit.
Okay.
Your Lordship may kindly consider my prayer for interim prayer, Your Lordship.
Upon consideration of the contention made in the petition and upon hearing the Land Council for the petitioner, it is provided that the impugn order dated, the operation of the impugn order dated 29/4/2024 and the 24/5/2025, 29/4/2022 passed by the Lana Civil Judge Senior Division, and What is it?
29/4/2022 is by the Kaba, Your Lordship.
22 by Keba.
Yes, Your Lordship.
Okay, 29 for by Keba of which village?
This is Pakam village, Your Lordship.
Pakam village, and order dated 24/5/2024, passed by the Lana Civil Judge Senior Division Alo, shall remain stayed till the next returnable date. Okay.
I'm deeply.
I was asked to present in the.
Oh, yes, yes.
In channel
So that the respondent sought for adjournment as the respondent, counsel for the respondent is sick, some of the counsels. So special
What
Mr.
that
I.A.
happening, my
Ganguly.
lord, this is unfortunate thing that is happening is
Hmm.
the learned senior counsel is appearing on behalf of the Honorable Guwahati High Court.
Hmm.
I'm appearing as amicus curiae, and they are taking adjournments without informing us. That is the difficulty. The
Oh, I
whole-
thought,
Now, of course, if there is some difficulty, we understand, my lord.
hmm.
But this is a case, my lord, trial is going on. The Honorable Court has taken suo motu cognizance that the procedure has not been followed. It's a bail cancellation matter. This needs to be heard at some point of time, otherwise
Right. Hmm.
it becomes infructuous.
Now, what is the status or the stage of the trial?
Trial, I'm not aware, my lord.
Not at all.
Yeah.
I think accused, probably how many accused?
Evidence.
Some around,
Evidence is going on there.
Evidence is going on. So what we'll do is we will fix and on the next date.
Yeah.
Give them a last opportunity for appearance because one or other accused person will have
So
seen.
there are
that-
so many.
Yeah,
Yeah.
today,
Counsel appearing on the other side.
was also today is also for last date.
Last date.
It should be disposed today as per the
No,
earlier
ah.
order.
So,
Earlier order.
Now, if somebody's health is not good, obviously, your lordship, the other way.
the Lana Council appearing for on behalf of Mr. I.A. Ganguly, Lana Council, the respondent, Lana Council for the respondent. Praise for adjournment with the matter on the health, on the ground that the council appearing on behalf of the respondent accused is okay, not well today. Stop. Third, they have they given name?
Yes,
Okay.
I provide.
Mr. Mook Patil Management Advocate, Standing Counsel for the Guwahati High Court, and Mr. Ipang Amicus has objection. However, considering that the counsel for the respondent is unwell, the matter stand adjourned. The prayer for adjournment is granted as a last chance. Okay, list is matter after 3 weeks. The date will be fixed.
Better a dead manner than they will say they did not know because there's someone who are based outside also.
When do we fix them? After 3 weeks? Probably the bar also has some problem, I think.
Yes.
Someone mentioned. So we'll fix it on March. 9 March.
9 months.
Right.
Okay.
State presence may be recorded. madam.
Okay.
9 months.
Okay, state now, Mr. Ete for Ete additional PP for the state. Okay. He's also present, huh? Okay.
Item number 2.
Give the name, huh? Give the name and respondent. Okay. Item? Okay.
May I, Your Honor?
Yes.
Your Honor, this is an application under section 482 of BNS, praying for granting of an anticipatory bail to the alleged accused person, Mr. Tanya Chek.
Okay.
In
Your
connection-
earlier bail was rejected. When?
It was rejected on 4th. For 04/02/2026.
Okay. Offense is 85-109,
Yes, Your Honor.
118 to BNS. Oh, attempt. Okay. Why it was rejected?
My lord, it was rejected on the ground that the accused, just give me a second.
Okay, the accused also while absconding, the accused also tried to withdraw amount from the joint account by forging the signature of the victim. That is too much. Okay, what is his antecedent? Have you stated that he has no other criminal case pending against him?
Yes. Your Honor.
Where?
Yes, it is.
Where?
Page number 9, my lord.
Page number 9. It's page number 9.
Para?
Para 19.
Para number 19.
It's only bail application is not pending. Criminal case pending against. Antecedent, I'm asking about the antecedent. This is no bail application is pending. Where is the statement that there is no any other case, criminal cases pending against the accused person in any other court?
Para number 18.
18.
Para 18. Furthermore, he has no criminal incident and he being a regular government employee.
Well,
Is
furthermore,
yeah.
he has no criminal antecedent. Okay, he's a government employee also.
government employee.
But why? But see the conduct. It will be difficult, Land Council. The conduct while absconding, you try to withdraw by forging also.
Your Honor, actually, this forging is just an allegation. This is just an allegation that it has not been proved. It is just an allegation.
Yes, please. Jenny?
Yes, Your Lordship, Your Lordship will see the allegations are of very serious in nature.
Yes.
And I also, with regard, if I go through the rejection order on 4/2/2026, Your Lordship will see that there was also a lookout circulation against him, Your Lordship.
He
And
did not cooperate.
He did not cooperate, Your Lordship. And that's the very reason. And there was also impression made upon the court that there are two crucial witnesses who are to be examined, Your Lordship. And there is a chance that
Examined by the police.
police, Your Lordship.
Police has not yet examined when the FIR was lodged, by the way.
FIR was lodged on 24/1/26, Your Lordship.
24.
Hmm.
Now, what prevent the police to examine the witness?
Your Lordship, that can be ascertained only through the CD, Your Lordship. Because,
Arrest, we understand.
yes,
If he is hiding somewhere, it will be difficult.
yes,
But
because,
then such a long
The-
period also for two.
Your Lordship will also see that it seems the victim is still
Under treatment.
under treatment, Your Lordship. And the allegation of grievous hurt there in this matter.
Mhm. It's a serious.
Yes.
Mhm.
The rest, Your Lordship, because there, it seems there is a circulation which I have also been apprised by my learned counsel for the
What
victim, Your
circulation?
Lordship. There is a circulation, there is a circulation lookout,
Notice has already been served,
Okay.
but he's at large.
because if this lookout notice was issued while declaring him as a proclaimed offender or absconder, Your Lordship, in that case, there is he does not have any right as such to apply for anticipatory bail, Your Lordship. Therefore, Your Lordship may allow me to
Mhm.
obtain a CD, Your Lordship.
Mr.
Milord, at the same time, Tinalo, may I, Milord? Milord, at the same time, this accused is threatening to the family members of the victim.
Okay,
So-
you are for the
I am for the victim, Milord.
victim.
Yes, victim is still at, in the hospital, Trims Hospital.
You file Wakalapnama? to
Yes.
assist the-
Yes, this morning I have filed Bakalan Nama. Milord, Milord can see the photograph also. I brought the photograph also,
What photographs?
the cut mark of the photograph.
That's not, obvious it is serious only.
Yeah,
26.
very serious.
So 118 is there.
Not only injured to the victim, but to the, now he is threatening to the victim family as well, Milord.
Hmm. Look. Mr.
Tinalo.
Land Council for the petitioner. I've also had Miss T. Jenny, Land additional PP. And Mr.
I am caught up on.
Upper Land Council appearing on behalf of the victim, assisting the additional PP. Apprehending his arrest in connection with this is a Daporejo case.
Yes, Daporejo.
DRJ PS case number 01/2026 under section 1091 1182 of BNS 2023. The petitioner filed this application under section 4. It's a 482. Okay, 482 of BNSS 2023 seeking grant of pre-arrest bail. Stop. Call for the case study. This test matter when? On 12. Okay, this is matter on 12. Okay, considering that considering the serious nature of allegation against the accused and the earlier bail was rejected by the Lanet Session Court on the ground that there is a prima facie case against the accused and during and while absconding from arrest, the accused mischievously tried to withdraw amount from his joint account with the victim by forging her signature, and that there is a possibility of and that there is a possibility of his influencing the material witnesses, and also considering that the accused, while on absconding, is threatening the victims of the family who are threatening what?
For settlement.
For settlement. This court is not inclined to grant pre-arrest, grant
not
interim relief.
The
Interim bail, huh? Staff, huh? Okay, this is matter on 12. Okay.
grateful.
Item number 6.
Yes.
Your Lordship, matter has already settled before mediator, and settlement agreement has already furnished.
That already settled?
Yes, in mediator.
Before mediator.
Not before the mediator. That's not before the mediator, Your Lordship. This matter was sent for mediation, Your Lordship,
Okay.
on the last occasion.
Hmm.
However, Your Lordship will see that all
Mediation means between the parties.
between the parties. But since all the sections here were compoundable, therefore the Honorable Court did not feel it appropriate to send it for mediation, because for mediation, only non-compoundable cases have to be cited.
But now since this court has directed and they have also
No,
settled,
no. So what, I'll try to, Your Lordship.
the
On the
proper,
last-
the proper procedure is under 320.
On the last occasion, what they have stated that the parties has come to a settlement, Your Lordship, and they produced the settlement order before this court, Your Lordship. But this honorable court has asked them to file an appropriate affidavit bringing into report the settlement. Otherwise, we also don't have any objection if the court quash this matter.
Where is the settlement order?
On dated 4 August, February.
Okay, where is the
Okay.
copy?
Well, we have produced the photocopy to the mediator also, before the mediator. Here is the original settlement deed.
Okay, you file in the form of affidavit.
Your Lordship,
Hmm?
I
Just
deeply
a minute.
apologize.
Hmm.
One of the factors that we have raised was that under 482 of CRPC, Your Lordship, for quashing, Your Lordship,
Mhm.
only non-compoundable matters has to be quashed on settlement. Earlier, this matter had been argued on merit, and therefore, under 482, this court has entertained this application, Your Lordship. Now, subsequently, if the parties has come before this court with a settlement agreement, Your Lordship can refer them back to the trial court for compounding of the cases, because all these sections are compoundable, Your Lordship. This court under 482 cannot entertain a compoundable case.
What is
terms
this?
of-
This is settlement deed is November, January. What is this, handwritten?
My lord, that settlement is
Settlement of some other party?
executed between the parties.
What is the name of the party?
Gandhipara, my lord. My lord, in connection with this matter, there was one criminal petition, 225 of 2023, my lord. It was also settled before the mediation, my lord. And-
See,
Yes,
if the parties have already settled,
yes,
you
ma'am.
have an option to approach the trial court that parties are agreed, and since the offense is compoundable, compound it under 320.
Lordship.
Why you did not approach if the parties have amicably settled the matter?
My lord, since the petitioner has filed this criminal petition before this,
Why you had to file? Because if there was an agreement between the parties, why you had to file?
Your Lordship, this settlement was done after filing of this petition before this Honorable High Court.
Settlement.
Yes.
my lord, here I'm on behalf of the respondent number 4 and 5, my lord. My lord, in connection with this matter, there was similarly there was another matter, my lord. It was referred to the mediation on August 2025, my lord. Techi Boy versus the state of AP. My lord, it was settled in the mediation, my lord. And following that case, my lord, it is the connected case, my lord. Here also on the 28th January, my lord, 2026. This court has referred this matter to before the mediation, and before the mediation on 4th February 2026, my lord, both the party, they have agreed to settle. So, my lord, with this settlement deed and with this
This is
with
same
this
case. No,
my lord,
different case.
yes, it's different case. The connected case, it has been already settled before this court, my lord.
Connected case means same case.
Yes, there was two accused, my lord.
Okay.
The Techi boy, that matter has been already disposed. It was not
Also,
sent to the
also in
trial court. It
in
has
the
been,
same PS case.
yes, my lord.
Just a minute, huh?
So, my lord, if we refer this again to the trial court, it will
But
will end the
suppose
process.
you see, you are advocate, you knew that it's a compoundable.
Yes, yes,
Why
ma'am.
you had to approach?
Because before there was no settlement.
Hmm?
After filing of this case in this honorable court. after
Why
the
you had
settlement-
to, because here, under 482, 528 now,
Hmm.
is only with regards to the non-compoundable case only. Knowing that this is compoundable case, why? Because sometimes when the advocate mentioned at the submission of the advocate, we issue notice. But then you have to apprise the court that this is non-compound, this is compoundable. Just a minute, huh?
Your Lordship,
What is the PS case number? Just a minute, huh? It's same.
yes, case
Yes,
number.
yes, madam.
Section,
Both are same, yes.
that is and so.
I know 30th of 2022, ma'am.
What is the GR case?
Six 2022.
Okay, 685, 2022,
Yes.
section 448. Yes.
Yes, 448, 323 and 341.
The case has already been.
Yes, Your Lordship. I'll just apprise Your Lordship about the case even of the Techi boy, Your Lordship.
Quast also.
Yes.
But here you see, must have said
Yes,
the accused is only one accused.
all the matter is compoundable also.
Should have been said that had you informed the court, that court could have said that in respect of that accused, already set aside in quast.
And it's unfortunate. What I'll just apprise this for Your Lordship. Lordship will see that on 31st of July 2025, there is also a notice that I have placed on earlier occasion, Your Lordship.
Mhm.
Your Lordship will find that it's a
31st
mediation
order,
order. mediation.
31st?
It's a dated 31st of July 2025, Your Lordship. Dada, mediation order. I've given in a loose sheet on the last occasion. Your
No, this
Lordship.
is in order, not in order, not the order.
This is
Order of this court.
no, Your Lordship. There is a circulation notice given to the registry by the secretary, Your Lordship, of the Guwahati High Court Mediation Center, Your Lordship.
Hmm.
Your Lordship, I found
It's
it.
not there.
There is a communication.
Where do we find?
On the last occasion, I had in fact submitted before this honorable court, Your Lordship.
It's not there.
There is a loose sheet.
No, it's not there. Do we have the copy? Just read.
I दादा आपका
Read it.
प्रिंटर है I'll just
What it says, just read.
it says there was a communication from the Secretary Guwahati High Court Mediation Center to the registry of this bench with regard to the mediation campaign of NALSA as per the Apex Court's order, Your Lordship. It says that at Annexure A, it says that, if I may read, Your Lordship, all matters having elements of settlement, including matters pending under each of the following categories, may be referred for mediation. Matrimonial dispute, accidental claim, domestic violence, check bounds, commercial disputes, service matters, And in terms of criminal compoundable cases. So only those matter which are,
Compoundable case, that is why it was forwarded to or referred to.
no, no, no.
Hmm. They are in the Lok Adalat also, only the criminal compoundable case can be forwarded or
Yes.
sent.
Including
Since it is a compoundable, that is why it was sent to mediation.
mediation, Your Lordship.
If it is a non-compoundable, it cannot be sent to
Yes.
mediation. Mediator cannot, or mediation cannot decide. Okay, anyway, so since the
And there,
similar case in respect of the another accused has already been set aside and quashed.
yes,
This would,
this matter may
next
be
time,
then referred to the mediation.
no, already referred. Mediation already settled, it appears. There is an order as directed by the office note is also there, and it was referred to the mediation only. Yeah, probably since it was a compoundable, that is why it was referred
Yes.
to the mediation.
Now the parties, if there is any agreement to that, the party may, in that terms,
Since the offense are compoundable in nature, the question of to be considered by the court.
so when the mediation center will take up this matter, otherwise, Your Lordship.
Yeah, mediation took up the matter and settled
Okay.
as directed.
Order time.
Settlement through the office note also says that for settlement through the office note is directed by High Court. It was sent to mediation for settlement through mediation, huh? Process between so and so. Joint Register Coordinator has submitted a report to the registry and so much place. Okay. So he has placed.
The
Just a
order
minute,
of the
place
mediation.
A. Just a minute, yeah. Okay. It is reported by the mediation that the case has been amicably settled as reflected in the order dated so and so passed by the mediator. There is order settled.
Yes. In that terms, in terms of the mediation order, Your Lordship may dispose of this matter.
Mr. Amis,
A. Rai.
Learning Counsel for the petitioner. Also had Miss Jenny, Learning Additional PP, Arunachal Pradesh, Additional Public Prosecutor, Arunachal Pradesh, appearing on behalf of the state respondent number 1.
And for the respondent, they have made, and for the respondent number 1, 2, and 3. Your Lordship.
1, 2, and 3. And Mr. GR Learning Counsel, appearing on behalf of the respondent number 4 and 5. Staff, fair. This criminal petition under section 482 of the Code of Civil Criminal Procedure. No, it's 482. When it was filed? It's 482. It should have been 528.
It was filed on 2/12/2023. This matter, Your Lordship.
But it was filed under CRPC only.
Yes, Your Lordship.
Okay.
Since the offense had taken prior to coming of the present.
Okay. Sorry. Prior to, okay. 482 of the Code of Criminal Procedure, 1972. Has been filed by the petitioners, huh? Only one petition.
Yes. Yes.
Okay. Petitioner praying for quashing and setting aside of the criminal proceeding in GR. Is GR case same?
685, 2020.
GR case number 685, 2022, arising out of. This is which PS case? Chimpu.
Chimpu PS case number
Chimpu PS case number 30?
38.
38.
of 2022.
of 2023,
2, Your Lordship,
22, registered under section
448,
448,
323.
323, 341, 34 of Indian Penal Code. Presently pending before the Chief Judicial Magistrate.
Yes.
Chief Judicial Magistrate, UPR.
Capital Complex UPI.
Hmm.
CGN 48.
On being agreed by the parties, this matter was agreed upon by both the Rana Council for the parties. This matter was referred to the High Court Mediation Center, Itanagar, for amicable settlement of the dispute between the parties. Pro mediation. Stop. It is submitted that the matter was amicably settled between amongst the parties before the mediation center on when it was settled on 4/2/2026. Stop. The High Court Mediation Center has also has submitted its report indicating that the matter has been amicably settled between the parties on 4/2/2022 on the same day. Stop. What is the terms of settlement?
My lord, the settlement deed is the vital one, and following the settlement deed, there is undertaking and apology letter.
Okay.
The settlement deed, there has been
Okay.
put out.
Para. 40,000?
No, my lord,
Okay.
in the settlement deed itself, we have written the terms and conditions name.
Okay. Why these two settlement orders? Okay. Apology also.
Following agreement of the settlement deed, that settlement deed is the man,
Hmm.
and accordingly, they have also produced the apology letter and undertaking.
Who has undertaken? Accused.
Yes.
Apology is by,
Accused, co-accused.
and then
Oh.
undertaking is by.
Same
person.
Okay. The settlement before the mediator includes that the accused shall tender a written apology and undertaking acknowledging his mistake and also not to repeat such mistake in near future. Accordingly, the petitioner stroke accused has tendered apology on 18/11/2025 and has undertaken not to repeat the same. Has undertaken not to repeat the mistake in near future on 18/11/2025. Start on para. The on tendering of such apology and undertaking, the respondent informant has agreed and accepted, and has expressed that they have forgiven the accused petitioner, and as such they have no further grievance against the accused petitioner, and therefore they have no objection to the no objection if the prayer for quashing of the proceeding against the accused before the court of, which court you said, Chief Judicial Magistrate, UPR, is allowed. Stop. The Learned Counsel for the party submits that since the matter has been amicably settled amongst the parties, the proceeding against the accused petitioner before the Learned Court of Chief Judicial Magistrate, UPR, be set aside and quashed. Stop. So you have no objection.
I deeply apologize for interfering, Your Lordship. Your Lordship will see that Your Lordship is allowing this petition only on the report of the mediator.
Yes, based on the report.
Not in terms of this agreement.
In terms of the report.
In terms of only the report, not of the agreement, because if the Your Lordship is dictating in terms of
No. So the entire thing will not come.
Yes.
Only a report of the
mediator. That
joint registrar
yes.
had submitted report.
Yes.
The mediator has submitted report to the joint registrar and brought on record.
Yes, only on the
Okay.
quashing, only on the basis of
The additional PP, Arunachal Pradesh fairly submits that in view of the amicable settlement between the parties before the mediator, she has no objection if the prayer is allowed in terms of the report of the mediator.
Yes.
Okay, stop. Upon hearing the parties and on consideration, and considering that the dispute have amicably been settled amongst the parties through mediation, this court is also of the opinion that, of the view that the dispute is in between the private individuals and apparently does not affect the society at large.
Your Lordship, that was my point, Your Lordship. Your Lordship may not take into consideration the settlement submitted by them, only on the report of the mediator.
Okay.
Because
Then parties through mediation, this court is of the view that the report submitted by the mediator regarding the settlement of the case by the parties can be accepted.
yes,
Accordingly, then we don't have to refer any other
no,
That-
not to agreement, because if just a
any other.
I'm just clarifying the law, Your Lordship.
Hmm.
Since Your Lordship cannot invoke 482 for the settlement, Your Lordship,
Hmm.
settlement was produced before the mediator, Your Lordship.
Hmm.
This court on the report of the mediator can
Okay.
quash this petition.
In view of the above, and is agreed upon by the parties, the proceeding of GR case number 685.
Yeah, it's real person.
35,
2026 too.
2022. That mediator settlement, it has come to the settlement only because of that settlement meeting. That what the party, they agreed. And that is why. Therefore, only that in the mediator itself it was settlement. Okay, arising out of Chimpu PS case number 22, huh? Chimpu PS case number
38, 22,
28. 28 or 38?
38.
38, 2022. Registered under section 448, 323, 341, 34 IPC. Pending before the Honorable Court of Chief Judicial Magistrate UPA against the accused petitioner Mr. What is it?
Gandhipara.
Hmm?
Gandhipara.
Gandhipara Passam. PHASSA and you are hereby passed in the interest of justice.
Deeply.
So, how many accused are there in the present case?
There were 2 accused.
Only 2.
Yes.
And in respect of the other accused?
Already was.
Okay. The Learned Counsel for the petitioner also brought an record the order of this court dated 25/9/2025, passed in criminal petition 225/2023, whereby the proceeding in GR number 685/2022 arising out of the Chimpu PS case number 38/2022 under section 448, 323, 341, 34 IPC in respect of the another accused. What was his name?
Pichi
Boy has been quashed. In view of the above, the proceeding under GR case number 685/2022 arising out of same, the Chimpu PS case number 38/2022 under section 448, 323, 341, 34 IPC against accused persons hereby quashed in the interest of justice. With the above, the instant criminal petition stands disposal. Okay.
Deeply.
This in the mediation report. This is not a mediation report. Okay.
Item number 10.
If I may please, Lordship.
Yes.
Lordship, this criminal petition was filed against the FIR for quashing of the FIR.
Yes.
Yes, Lordship, during the pendency of this case, charge sheet of the case and then the cognizance by the Honorable Trial has already been done. So I may be allowed to withdraw this petition and may be allowed to file afresh.
Okay. Miss
Dhiruba.
Land Counsel for the petitioner submitted during the pendency of this criminal petition, the police after completion of investigation has already filed charge sheet and the Learned Trial Court. Which court?
CJM.
Learned Chief Judicial Magistrate has fully taken cognizance of the case and trial proceeded.
Yeah.
Okay, therefore, she may be allowed to, and in view of the above, therefore, she submits that she may be allowed to withdraw this with petition, this criminal petition with liberty to file afresh after incorporating the subsequent development. Incorporating the subsequent development in this case. Striking. The Mr. Theatre Land Additional PP has no objection. But in view of the above, this criminal petition stands dismissed with liberty as prayed for.
Obliged.
Much obliged.
Matter number 11.
Take the record. That's-
Please, Your Lordship.
Yes.
Lordships, TCR was called for today. And
Okay.
in this case, already trial proceedings takes place.
Okay, trial court record was called for.
Yes, my lord, and it's a POXO matter, my lord. Whether the petitioner has served the copy to the legal aid council or not, that has to be ascertained. my lord.
Record
I
was
have
not yet
served-
received. Huh? Have you served copy?
Yes, Lordship, I have served already. On
In view of the above, let this matter be listed after 3 weeks. In view of the above, let this matter be listed after 3 weeks.
after
The-
1 week, Your Lordship, because the trial of the case.
Which court?
Larned special courts, UPR.
Earlier, your bail was rejected.
Earlier, it was rejected by the Larned court below. Special
Trial court. So now, probably. Okay, it was rejected at what stage?
It was rejected. In this case, accused petitioner was not arrested. This is a case registered in the year 2018, Your Lordship. Only after non-bailable warrant of arrest was issued against the.
Okay, and the accused was not arrested in the
Not
case.
arrested.
Only he was arrested in execution of the warrant,
Yes,
non-bailable
when he
warrant.
surrendered before the Larned special judge
Okay,
and filed. the
and then
petition.
since he did not cooperate and appear before the trial court, he has
Trial
been.
court, and he was not aware that case was registered against him. Because most of the time he was not staying in the place where the alleged offense took place as allegation in the FIR.
Okay. No, just a minute. Huh? No, thereafter, have you filed any bail application?
Yes, thereafter.
That was,
That was rejected.
that was also rejected. But he was arrested only in execution of the warrant only,
NBW was issued against
NBWA only.
after getting information from Palin police station regarding the NBW issued against the alleged accused person. He then surrendered before the Larned special.
No, after surrendering,
After
when,
surrender,
after he has been taken into custody, whether he has filed
yes,
application,
yes,
bail
he
application.
have filed bail application.
Okay,
that was
subsequent
rejected.
bail application. So that has been rejected.
I have
Okay, on what ground?
that subsequent bail was rejected, that endeavor will be made to complete the trial as possible.
Okay. So his
At
presence
this
was in.
stage, bail cannot be granted to the alleged accused person.
Vulnerable. Okay. Whether now the victim has already been examined?
Victim, not yet.
Not yet.
Earlier, November 18 was fixed for the victim and the complainants.
When is the next date
Next date
fixed
is
for
on March
examination
30.
of victim?
Next date is on Your Lordship on March 13. So there is a very delay.
March 30
And
for examination of victim.
yes, victim and the complainant.
Mhm.
And this is a case of 2018. And
March would be too long.
Yes, my lord, that can, the direction can be given to expedite the trial, my lord.
Anyway, let us see the record.
Yes, madam.
Okay.
Let us see the record.
and
Okay.
already alleged accused
That-
person in jail for more than 6 months.
Trial court record. Okay, he is still awaited in view of the.
Legal aid is also present now.
Huh?
Legal aid for the victim, my lord.
Okay, victim. Victim not yet examined, it appears.
No,
Okay,
13-3, I think, that's good.
13-3.
Yes.
Let us see the records. We'll say.
Earlier it was on 18 November, but there was
Now,
no court sitting on
13 March.
13.
Now more than 1 month. from,
Let it be after, my lord, examination of the victim, my lord.
that will be better.
Yes, my lord.
Because in any case, in POXO, the informant and the victim has not yet been examined. It will be difficult.
Yes, my lord.
And the court also made same observation. I've seen.
After,
The thing is that, your lordship, we have why approach before this honorable court is the ground that it is taking delay.
But see, there are other cases also.
But in POXO case should be expeditiously tried as per the law.
Yes.
So it was fixed on 18 November for PWs of 1 and 2, the victim and the complainant. But due to no.
That will happen only if there is a less POXO case. But the people like you make increase the cases.
also
what to
presumption
do?
is there.
Hmm.
My lord, after 13 only, my lord, it can be ascertained
Okay,
whether
so
it's,
we'll-
delay,
yeah, let
delay
it
is causing.
get it listed, because no point calling a record also. Only that because I've seen the reason for rejection.
Let it be on 16, my
Yes.
lord, 16 or 17, my lord. On
Yes.
13 is the
Okay.
examination.
Okay.
And 14, 15 is Saturday, Sunday, my lord.
Okay. On the request of the Lanet Council, the Lanet PP and the Lanet Legal Aid Council appearing on behalf of the write his name also, huh? On behalf of the victim, list this matter again on 17.
Yes, my lord.
Okay, the registry shall issue reminder
Yes,
for
ma'am.
trial court record. Okay.
My lord, up to date trial court record, madam. On, if it is on
Okay,
17.
the updated trial court record.
Yes, ma'am.
Okay.
Deeply obliged, madam.
Item number 12.
Please.
Yes.
In this matter, there are 10 respondents. As per as per office note 5 of this month, the service report to the respondent number 2 to 4 and 6 to 10 is still awaiting.
Okay.
So this matter
You
may
are
be
for
Respondent number 5.
5.
Yes, ma'am.
Okay, hard Mr.
T. Shibo appearing on behalf of Omodi.
Lanet Council appearing on behalf of Mr.
Omodi.
Modi,
T.
Lanet
Shibo.
Council for the petitioner. Also hard Miss
B. Palon on behalf of N. Dangan.
B. Palon appearing on behalf of Miss N. Dangan, Lanet Council for the respondent number
5.
5. Staff, the office note dated 5/2/2026 reflect that you have to take fresh steps upon respondent number 1, it appears. The petitioner has not yet taken a fresh step for notice upon the respondent number 1 and service report upon the respondent number 2 to 4 and 6 to 10 are still awaited. Stop para. In view of the above, the petitioner is granted 1 week time to take fresh steps upon the step for notice upon the respondent number 1. You take fresh step upon respondent number 1. Okay.
Yes.
Okay. List this matter after 3 weeks. Okay.
Obliged.
Item number 13.
Yeah, my lord.
Hmm.
My lord, I need some time to file affidavit reply.
You are for respondent number 1.
Yes, I'm the
Okay.
sole respondent.
Sole respondent.
Yes.
Name reflected.
Yes, Titaggu.
Okay. Mr. T. Taggu, Lanet Council appearing on behalf of, who put appear on behalf of the sole respondent.
Yes.
Press for how much time?
You're on 2 weeks.
Press for 2 weeks time to file response to the petition. Start, huh? The prayer not being objected is allowed. Mr.
Dear,
Not being objected by Mr. B. Madhav, learning counsel for the petition is allowed. Stop. Is granted. List this matter after 3 weeks.
there is an interim that may be sent.
Interim order passed earlier shall continue till the next date of listing. Okay.
Much obliged.
Item number 14.
Yes. This morning, somebody mentioned, I think. Yes, sir. Aj. Mr. Ms. Iran, learning counsel. Submitted the conducting counsel, Mr. L. Parme, has some difficulties today, personal difficulties today. Therefore, pray for adjournment, to which Ms. Sumu.
Yes.
Learned government advocate has no government advocate. For the state is a respondent here.
Yes, ma'am.
For the state respondent, is no objection. Prayer allowed. List this matter is prayed for, comma, list this matter after?
Two.
2 weeks. Okay. Okay.
Item number 15.
Your Lordship, I'm for the petitioner.
Okay.
Petitioner number 1 and 2. So Your Lordship, this case is for quashing of an FIR.
Yes. Seems the service of notice upon the respondent number 2 is still awaited.
Yes,
Who is
yes,
respondent number 2? Is a private respondent,
Yes, Your Lordship.
informant, complainant. Who?
Yes, my lord. 379, my lord, it's a private respondent, my lord. Srimati
It is still awaited.
Yes, my lord.
So you have taken step recently or it appears? So,
Complainant, my lord.
Miss
R. Drema.
R.
Drema.
Learning counsel for the petitioner is present. Mr. Telane, additional PP, who is also present. The service of notice upon the respondent number 2 is still awaited. In view of the above, let this matter be listed after 2 weeks.
Yes.
2 weeks.
Your Lordship, we may be allowed to take fresh steps.
Fresh steps.
Yes, Your
When it
Lordship.
was okay. Just a minute. And then
Last year.
okay. Then Miss Drema, non-counsel for the petition. So in view of the office note dated 5/2/2026, Miss Drema, non-counsel for the petitioner, prays for allowing her to take fresh steps upon the respondent number 2. Stop. The prayer is allowed. Press steps upon for notice upon the respondent number 2 by speed post with 80 as well as by usual process within how many days? How many days you required to take steps? Within 3 days? 3 days. 3 days.
Your Lordship.
Okay. List this matter after. Then where is the respondent address of the respondent? 3 weeks. List this matter after 3 weeks.
Your Lordship.
Yes,
Itanagar only, my lord, A sector.
Yes.
Let them
The
take,
address is the same. It's same, Your Lordship.
Okay.
let them take steps through, my lord, jurisdictional PS, it will be better.
Okay.
jurisdictional.
Yes, Your
Itanagar
Lordship,
Pro-judicial
Itanagar
PS. Okay.
it will-
Your
Obliged.
Lordship, I also like to mention, my learned senior counsel name had not listed. So
Hmm?
my senior counsel name should have been listed, not reflected in the
name?
cost list today.
Okay, what is his name?
G. Kato, Your Lordship.
Okay. The registry shall, registry shall reflect the name of Mr. G. Kato.
My lord, it may be directed that they reflect the name of the council who have filed the wakalatnama.
Wakalatnama, how
If he
many?
has filed the wakalatnama, it will be reflected in.
G. Kato and other. You have filed Wakalatnama? It's not there.
No, Your Lordship.
Okay, shall reflect the name of the counsel for the petitioner in the cause list. Okay.
Yes. Obliged.
Much obliged.
Item number 16.
Your Lordship,
Yes.
service awaited in respect of sole respondent.
Okay. Mr.
Sita Jo appearing on behalf of
Lani counsel appear on behalf
Vijay Jamo,
of
Vijay Jamo.
Jamo, Lani counsel for the
Petitioner.
petitioner. Staff. The office note dated 5/2/2026 reflect that the service of notice upon the just a minute. Okay, sole respondent is still awaited. You want to take fresh steps?
Yes, sir.
Okay. Service, when it was taken? Yes, you have to take. Okay. Then Mr. So-and-so, huh? He is present in view of the order, in view of the office note dated 5/2/2026. The Lani counsel for the petitioner prays for allowing him to take fresh steps upon the fresh step for notice upon the sole respondent. Prayer allowed. Steps upon the sole respondent by a speed post with AD as well as by usual process within 4 days from today. List is matter after 3 weeks.
Your Lordship, here is interim.
The interim order passed earlier shall continue till the next date of listing.
Possible.
Item number 17.
Yes.
Your Lordship, I'm for petitioner and service report in respect of respondent number 3 to 7 are still awaited.
Okay. Service. So you want to take fresh steps?
Yeah.
No.
Yes.
Okay.
Step.
The service upon the service of notice upon the respondent number 3 to 7 are still awaited in view of the above. Then counsel for the petitioner Miss
Rai.
prays for allowing her to take fresh steps. Prayer allowed. Steps upon the respondent number 3 to 7 by register force with AD as well as by usual process within a week from today. Stop. List is matter after 3 weeks. Miss Jenny Lanak, additional PC for the state is also present.
Your Lordship, there is the interim that may
The interim order passed earlier shall continue till the next date of listing. Okay.
Lordship, item number 18 also.
so related.
Same. Your.
Yes.
Okay, similar order in 18.
Item number 19.
19.
Your Lordship, we need some time to take step upon respondent number 2.
Okay. So you want to take fresh steps?
Yes, Lordship.
Okay.
Your Lordship, is criminal petition number 238 of 2025 and 237 of 2025, both connected matter.
Okay.
So kindly this matter.
Same. Okay,
both listing together.
okay. Mr.
Sita Jo appearing on behalf of
Raja.
Deepangi.
Okay, the service of notice upon the respondent number
Two.
2 is still awaited in view of the above. And the trial court record is also, and the trial court record as well as the service of notice upon the respondent number 2 as well as the trial court record is still awaited. In view of the above, Mr. G. Taju, Learned Counsel for the petitioner, pray for allowing him to take fresh steps upon the respondent number 2. Respondent number 2, prayer allow. Steps for notice upon the respondent number 2 within 4 days.
Okay.
By speed post as well as by usual process within 4 days from today. Stop. List this matter after 3 weeks. Okay.
Your Lordship, interim,
The interim order passed earlier shall continue till the next date of listing. Okay.
Obliged.
In both, 19 and 20. Okay. Yes, anything?
Next item, 20. Here,
Okay.
here we are seeking some accommodation to file an additional affidavit.
So, G. Tajo is in 20.
No, I'm 20. This item 20, my lord. 13
Okay.
of 25.
So,
26.
19 and 20 is connected?
No, my lord.
Okay. Which one was connected?
17 and 18.
17 and 18, my lord.
For 17 and 18?
Yes, my lord. The service was not complete, my lord, so the court
Okay.
is directed to await for the service report.
Okay, okay.
Now this item 20.
Then, and 20?
20. I'm seeking some accommodation here to file.
Okay. So why it has been listed for?
They were directed to file, my lord, the cognizance order, my lord. They have not
Okay.
made cognizance order as a part of the
This
record.
is
Criminal
petition?
Yes, for quashing.
Okay. Mr.
Tava. Later.
Taba,
Yes.
Learned Counsel for the
Taba.
petitioner. Praise for father.
Yes.
2 weeks? 2 weeks time.
In the meantime, interim maybe.
2 weeks time to file what?
My lord, additional affidavit to bring into record the cognizance order, my lord.
Additional affidavit.
Necessary record, my lord.
Okay, the additional affidavit to bring on record the necessary documents.
Yes, my lord.
The prayer is allowed. List this matter after 2 weeks.
So, and your interim is there, that maybe.
Okay. The interim order, the interim order passed earlier. Earlier shall continue till the next day of listing.
Yes.
And
my
his
lord,
present may also be.
yes, my lord. And reminder for TCR, my lord. TCR is not yet.
That trial court record is also still awaited. The registry is directed to remind for the trial court record.
Yes,
Okay.
Deeply obliged. Highly obliged.
What's it? Act 2? Act 2. Lodge. Resume Act 2.
Item number 21.
Your Lordship, in this matter, party is ready to settle the matter. So kindly this matter may be
Okay.
referred for mediation.
Okay. Mr.
Sita Jo appearing on behalf of
Learned
Vijay
Counsel
Jamo.
appearing on behalf of Mr. V. Jamo, Learned Counsel for the petitioner. Also had Mr. Okay, Learned Counsel appearing on behalf of Mr. Omadi, Learned Counsel for the respondent staff. This matter has been listed for referral to the special mediation drive, mediation for the nation staff. Both the Learned Counsel for the parties expressed that they are ready and willing, they are willing and ready to settle the matter through mediation staff. On perusal of the readings and the records, there is an element of settlement of the matter through mediation staff. In view of the above and as agreed upon by both the Learned Counsel for the parties, this matter is referred to, let this matter be referred to the mediation center staff, in mediation center for settlement through mediation. Mediation center of the Guwahati High Court Itanagar Permanent Bench for settlement through mediation staff. The registry shall do the needful for sending the record to the mediation center after appointment of the mediators and fixing the date and fixing the date. Staff. Okay.
Oh, let's.
Date for mediation. Okay.
Item number 22.
Please, the Lordship.
Hmm.
This matter, it is listed for mediation for nation, but
Yes, you are for the appellant. Who is for the respondent?
Respondent, New India Insurance Company, step, it was filed by Mr. Bolaram, my learned friend.
Okay.
The step has not been, service has not been completed.
Okay.
So we are ready, but the respondent party will have to know. So one more something.
You are for respondent or
I'm appellant here. Here.
appellant?
Yes, yes.
And then Bolaram is?
Bolaram also appellant.
Okay.
Yes. So
How the appellant? To appellant? You otherwise you are for which insurance company?
no. New
Okay.
India only.
Private. New India?
Yes, Bolaram is absent today.
No. You are for New India Assurance.
No. I am for appellant only.
Appellant. Who is the appellant?
Appellant is New India Insurance Company. As many as there are 3 appellants.
That is what I'm saying.
Oh, yes.
You are for the insurance company.
No, my lord. I am for appellant only.
Okay.
Yeah.
Who is the? What is the name of the appellant?
Appellant is Bobby Burman.
Bobby Burman is
Appellant.
okay. Appellant.
Yes.
Bobby Burman is claimant.
Claimant, yes, claimant here appellant.
Okay. Then
New
who is
India-
this Boluram represent whom?
Bolaram represents this Bobby Burman only. I am on behalf of Bolaram.
Okay. You are on behalf of Boluram.
Yes.
Okay. Then who is the respondent here in this case?
There are as many as 3 respondents. New India Insurance Company, top one,
Okay.
and
That is why. Because normally you appear on behalf of the insurance company.
yes, I'm
Okay.
here for. Bolaram.
Okay. So service not complete. There is also no record, not reflected in the record. Mr. Udeka, Land Counsel for the appellant is present. Applicant. This application is for, IA is for what? Condonation.
Condonation.
Okay.
It's for condonation. Yes.
Okay. He is present, however, none appears on behalf of the respondent. Have you taken steps?
Step was not taken. That's why
Mhm.
I may be given to take step.
No, IA already disposed of.
Or disposal. I already disposed of, yes.
No notice was issued then.
No notice was issued, my lord. That's why the notice may be issued.
So why it has been listed? Okay. Heard Mr. Udeka, Land Counsel for the appellant. Stop. Para. This is an appeal filed under section 173 of the Motor Vehicle Act 1988 against the judgment and award dated where is the
27/7/2026.
where do I find?
This is in petition, para one.
Which paragraph?
Page 3, first para.
Not in the course title. It should have been reflected in the course title itself. Award dated 27/7/2025, passed by the, which,
By Bombilla,
where do I find?
doesn't that
It should be, Planning Council, it should be reflected in the course title itself.
Yes, yes.
What petition you have prepared?
It
Who
was-
prepared this?
It was by Bolaram Das only.
B does. He used to make such kind of mischief.
Yes,
What is this?
not properly drafted, my lord.
Where do I find case number? Passed by the member Motor Accident Claims Tribunal, Bombdila, in MSCT case number 04/2024.
Yes.
See, only to see that the case number we have to see in the body of the petition,
Yes.
appellant, appeal.
Yeah.
How it is possible? 2024 for enhancement of the award. Staff issue notice. The appellant shall take steps for notice, the service of notice upon the respondents by a speed post with aiding as well as by usual process within a week from today. Stop. List this matter after 4 weeks. Okay.
Okay.
Just a minute. In the beginning, just right, huh? This matter has been listed for referral to the special mediation drive, mediation for the nation. However, it is noticed that the matter has not yet been admitted, huh? Okay, accordingly, yeah. Before issue notice, the appeal is admitted. Okay, then issue notice. Okay.
Item number 23.
Yes. Yes.
My lord, this has been listed in the mediation for
But
national.
then this was immediately filed, but no one appeared for the respondent. This has also not yet been admitted. No notice was issued. Whether notice was issued?
Notice. No, additional affidavit is filed. First, there was direction to file additional affidavit.
Okay. Where is the additional affidavit? Where is the additional affidavit? Sure. Where is the direction? Where is IA? Where is this IA 281? IA 281, where is? What is this IA for? Okay, delay was condoned.
Yeah.
Okay. Similar order, huh? Similar hard, Mr. Oh, you have received the copy? Okay, then are you ready for? Okay, just a minute, huh? Then we'll have to admit the appeal first. Okay, hard, Mr. M. Tara, Planning Council for the appellant. I've also heard Mr. Yu, the Planning Council, appearing on behalf of the respondent United India Insurance Company Limited. Stop. Huh? Para. This is this appeal. This is an appeal filed under section 173 of the MB Act 1988. For enhancement of the award dated. What is the date? 27. You have to mention the award dated. You have not mentioned, it's 0000. You have not corrected also.
No, only corrected in the affidavit. Only corrected.
It's not corrected.
22/7/2025.
Yes. See, it's not corrected. Announcement of the award dated 22/7/2025 passed by the Learned Member Motor Accident Claims Tribunal, Papumpari District, UP, in MSC case number 05/2023 D. That, Stop, The appeal is admitted. Issue notice. Since Mr. Deka, Learned Counsel for the respondent insurance company, is present and accepted notice on behalf of the respondent number 1 insurance company, no formal notice need be issued to the said respondent. Who are these private respondent? Okay. The petitioner, so the appellant shall take steps for service of notice upon the respondent number 2 and 3 by speed post as well as by usual process within a week from today. Stop. Thereafter only will honor and driver. Are they necessary party? For enhancement. Then they are not a necessary party. Okay. Then okay. Probably. Okay. Then since okay, the Learned Counsel for the appellant submits that the appeal has been filed for enhancement, and the respondent number 2, 3 being the owner and driver of the offending vehicle is not a necessary party for the purpose of disposal of this appeal, and therefore pray for striking of the name of the respondent number 2 and 3. Stop. The prayer is allowed. Let the name of the respondent number 2 and 3 be struck off from the course title at the risk of the appellant. Stop. The registry shall do the needful. Stop. Then the notice upon 2 and 3, leave it. Okay. Para. The Learned Counsel for the appellant and the respondent expressed that they are ready and willing to settle the matter through mediation. Stop. Para. On perusal of the appeal memo and appeal memo, it appears that there is an element of settlement of the matter through mediation. Stop. In view of the above, and as agreed upon by both the Learned Counsel for appearing on behalf of the parties, let this matter be referred to the mediation for settlement through mediation center for settlement through mediation. Stop. The registry is directed to take necessary steps for referring the matter for mediation after do the needful and appoint the mediators. Do the needful and appoint the mediators to settle the matter through mediation by fixing an appropriate date. Okay, list this matter. Oh, no, no, don't list, huh? Okay, list this matter after the mediation report. Okay. Okay.
Item number 24.
None appears on behalf of the parties. None appears on call. Huh? And none appears on behalf of the parties on call. Stop. List this matter after 3 weeks.
Finish, Lordship.